Okay, hello and welcome to Protecting Confidentiality of Justice-Involved Youth. My name is Zoe Shine, and on behalf of the National Juvenile Justice Network, I would like to welcome you. Before we get started, I just want to run through a few quick things about the software. So first, when you enter the conference, please make sure that you've enabled your audio. You have the option of joining the discussion via telephone or using your computer speakers and microphone. Because we have so many people on the webinar, everyone is muted to ensure we don't have distracting background noise. But later when we get to the question and answer section, if you would like to ask your question yourself, just hit the raise hand button next to your name in the attendee list, and we will call on you. Otherwise, you can use the question box and we'll read the question for you. If we don't have time to get through all of the questions, the panelists have kindly agreed to provide some written responses that we'll email out to all attendees within a few days. And finally, the webinar is being recorded, and it will be available on the NJJN website in the next day or two. So with that stuff covered, I'm going to pass it off to Melissa Goman of NJJN, who will introduce our panelists.
Great. Hello, everybody. This webinar is sponsored by the National Juvenile Justice Network, and we are a national membership organization made up of state-based groups. We have about 50 members at this time in 39 states, all working to ensure that the juvenile justice system is fair and age-appropriate for youth in trouble with the law. And we're being co-sponsored today by the Coalition for Juvenile Justice, which is a nationwide coalition of state advisory groups and allies dedicated to preventing children and youth from being involved in the courts and upholding the highest standards of care for youth in the juvenile justice system. So we have two wonderful speakers today. I'm just going to present some brief bios about them, and then we'll get started. The first presenter that we'll have today is Ria Saha Shah, and she is the staff attorney at the Juvenile Law Center. In addition to engaging in litigation and legislative advocacy, Ria leads Juvenile Law Center's Second Chances initiative. And she's the lead author of two recent national reports on juvenile records and expungement, which we'll hear much more about this afternoon, and has written extensively on the impact of juvenile records. And our second presenter will be Kristen Cornell. Kristen is the Director of Operations at the Delaware Center for Justice, or DCJ, which is one of our members. And she previously served as DCJ's Advocacy Coordinator for 2.5 years. And Kristen's responsibilities include advocating on justice-based legislation and developing public education and advocacy curriculum. So we're going to go ahead and get started now, and Ria will start us off.
Hello, everybody. Thank you. I'm going to just make sure I can move the slides. There we go. All right. Well, I want to start by just saying thank you to Melissa and National Juvenile Justice Network and the Coalition for Juvenile Justice for hosting this webinar today. I know that a lot of you that are participating have experience with the juvenile justice system and experience particularly with juvenile records, but I just want to start today with a little bit of history just to put everything in perspective and into context. So the underlying principle of the juvenile court system is really rehabilitation, and it stems from the idea that children are different from adults and therefore the law should treat them as such. Juvenile court is therefore distinct from criminal court. It's less formal and the goals are very different, while there has been a push in recent years to make it a more balanced approach with accountability and punishment as well as rehabilitation. The original goals really surrounded rehabilitation of the juvenile. In line with that, confidentiality was really practiced by most of these early juvenile courts, where it was seen as unfair to label kids as criminals because that characterization would really limit their rehabilitation. So as I had mentioned, in recent years, and really in the 1980s and 1990s is when this happened. I guess that's not so recent anymore, but in the 80s and 90s, juvenile crime became more prevalent and actually became increasingly more violent. And so state policymakers felt a lot of pressure to enact laws that emphasized accountability for the commission of the offense. And it changed the purpose clause, and a lot of states, state juvenile codes changed their purpose clauses to have a dual purpose of rehabilitation and punishment. So this really led to a shift in thinking about juvenile records. Juvenile records became more readily available to the public. Proceedings became more readily open. And the community really felt like they needed to know what was happening. They needed to know about these kids that were committing these crimes. State agencies were keeping juvenile records and having databases for particular offenses, and juvenile court information was routinely being shared with people outside the courtroom, including with government agencies and schools and the media. But currently what we know is that 95% of youth, the vast majority of youth who are in the juvenile court system, are there for nonviolent offenses. And what we also know is that these records of their offenses follow them throughout their entire life and into their adulthood and can cause harm as they become adults, causing limitations on the ability to obtain housing, to enter the military, to obtain higher education. And for a lot of kids, when this really comes up is because they have difficulty obtaining employment. And the reason why this becomes such an issue is because people don't really understand that juvenile records are not fully confidential. Even people who have worked in the field of juvenile justice for many years may mistakenly understand that juvenile records are confidential, that nobody has access to them, and that when a child turns 18 or is discharged from the court system, that they are completely erased or expunged. And that's just not the case. In the vast majority of states, records aren't fully confidential, and records are not automatically erased. So I want to start with just talking a little bit about why records exist to begin with, before we talk about why they need to be confidential. Well, in juvenile court, many of you work in juvenile court, or many of you have experience and understand why records exist, because there is a need to have there's a need to gather information about the child in order to provide for the appropriate levels of supervision. That's the primary reason why records exist at the time of the child's involvement in the court system. That information informs the juvenile probation officers in making their recommendations. It informs the court in making their determinations about disposition. It informs placement decisions, treatment decisions. All of this information is really important to fashioning an individualized disposition for each child. The records also exist because it is a way for data collection and for tracking criminal behavior patterns, as well as on some level for community protection. But records really need to maintain confidentiality because over time that information isn't as relevant. The utility of that information really diminishes. And what we know is that a lot of times records can contain inaccurate information and information that is no longer accurate because it is out of date. And also it contains a lot of information that can be stigmatizing. Juvenile court is unique from adult criminal court because a lot of information that's contained in a juvenile record file pertains to the juvenile's social history and educational history and family history, and all of that information can follow the child and result in things like a diagnosis being shared 15 years later that no longer is an accurate diagnosis. Records also need confidentiality because the maintenance of records over the course of several years really fails to appreciate the fact that we all know that children are different and they grow up and they become mature adults, and they're not making those same irrational and risky decisions that they might have made when they were teenagers, impulsive teenagers. And the final reason why is because records really do cause harm for many kids, that there are collateral consequences of juvenile records. So there are two primary ways that you can limit the exposure of a juvenile record and maintain confidentiality. So there's confidentiality throughout the court's proceedings. But then once a proceeding has ended, the way to limit the exposure of the juvenile record is by closing the record, by sealing it, or by expunging the record. And we talk about this in two different categories because they mean two different things, and it's really important to keep in mind that sealing and expungement are not interchangeable. Many people talk about these two mechanisms interchangeably, but really they're not. What the difference is that there is, for sealing, there is some limited accessibility still available. So terminology that might be used for something like sealing would be sealing or setting aside or closing records. So what this means is that for records may be closed to the general public, but some agencies or individuals could still retain access to the information that's contained in the record. So for example, sealed records could still remain accessible for law enforcement to use for investigative purposes. Usually sealing records or having that limited accessibility just means that they're not available to the public. Many states, however, have expungement of juvenile records, which really means no accessibility. Terminology that's used in different states could be expungement, destruction, eradication, and what we believe this to mean is that it is completely and physically destroying the record, and the effect of that would be that the record is as though it never existed before. That means that no agency or individual has access to a juvenile's record once it has been expunged. So keeping this in mind, and this is sort of the basis for how we approached our research, which I'll talk about in a moment, around juvenile records, sealing and expungement, it's important to keep in mind that what terminology is used may not actually be the correct terminology based upon the meaning. So when we know that it's true, when a statute says expungement, it doesn't always mean that records are fully and completely destroyed. In some states, records that are supposed to be expunged are still accessible to certain individuals, and so the effect of which is really that it is sealing. So using this as the basis, what we did is we undertook a study to evaluate every state's laws on confidentiality and expungement of juvenile records, because what we know is that states really vary in how well they protect records. The research that we conducted is all available on this website, jlc.org/juvenile records, and there are a number of different tools on this website that can provide you with a little bit more information. And I'll talk a little bit briefly about some of the things available and then go more in depth about using one of the publications that we've provided. So the first thing that is available on this website is a scorecard. It's a national scorecard that we set forth our core principles at Juvenile Law Center. We set forth our core principles for what makes good record laws, with the ultimate goal in mind that children shouldn't have barriers to their success just as a result of their involvement with the juvenile justice system. So once a child has been adjudicated delinquent and they've been discharged from the system, their records shouldn't cause them a barrier to success. And so we researched the confidentiality of records prior to sealing and expungement eligibility, so throughout court proceedings as well as after courts have discharged the case but before they're eligible for expungement, as well as the availability and process for obtaining sealing or expungement. And based upon the core principles that we set forth, we measured each state's progress in both these areas and gave them a final score on a 5-star rating. And by and large, what we saw is based upon our measure that the states didn't really do that well, that the average across all states was 3 out of 5 stars, and no state actually scored a high of 5 stars. But that information that we used, that core principle information, really came from an in-depth research study on juvenile records, and that's available at on the website as well. It's a national review of state laws on confidentiality, sealing, and expungement, as well as individual state fact sheets. So each state has a fact sheet where you can look at at the laws, the citations for the laws for your state, on how well your state has done on juvenile records, in protecting juvenile records, and assess the gaps. I mean, this isn't looking at it from the score measurement, but this is really just providing the information so that you can use it for your purposes, your advocacy purposes, as well as informational purposes. But I want to talk a little bit more in depth about the National Review. So much of today's presentation is really pulled from the National Review. This is an in-depth legal analysis of the laws governing juvenile records. It summarizes the law across all 50 states and Washington, D.C. on confidentiality, sealing, and expungement. As I mentioned before, we set forth core principles for optimal record protection, again, with the ultimate goal in mind that we want to ensure records don't cause barriers to kids' success as they become adults. And then we also provide recommendations for policy reform, and these recommendations are categorized, for state lawmakers, for state agencies, for defense attorneys, because we understand that, not everything is going to happen through a change in the law, that there are other ways to enact policy reform in a state, and so we provide those policy recommendations. But the core principles are really the meat of what it is that we are talking about. So in the National Review, we provided those policy recommendations based upon the core principles for record protection. And these are split up again in terms of the first three at the top are confidentiality of juvenile record information, and the last five cover sealing and expungement. So I just want to go through each one of these and explain to you a little bit about why we came up with the principle that we did and what the state of the law is around this particular principle, and then talk a little bit about how they relate to our policy recommendations. So as you'll see, the state of the law in terms of the confidentiality scores, it's much more varied than the overall scores. States scored very high. We had 5-star states, but states also scored very low in which they had many exceptions to confidentiality for juvenile records. But the first step to determining whether juvenile record information is kept confidential is to really figure out what is in the record. And so in every single state, we wanted to look to see what information was contained in a juvenile record. Because if a juvenile record is just the court orders, that doesn't really cover all the information that might be contained in a juvenile record. As I mentioned at the outset of the presentation, juvenile records contain a lot of information that can stigmatize youth, social history information, educational information, all of this information that may or may not be protected under other confidentiality laws and state confidentiality provisions. So we really wanted to make sure that in order to determine how confidential juvenile record information was, that the definition of what is contained in a juvenile record is as comprehensive as possible, that it lists all the documents that might be contained in the records. Secondly, we really wanted to make sure that juvenile records, the confidentiality of juvenile records extended to both law enforcement as well as court records. So law enforcement records could be records that are created or stored by a law enforcement agency, including arrest records or records related to the formal charges that are being made or the detention, fingerprints, or photographs or DNA information, all of this information that the police keeps or the law enforcement agency keeps, that would be contained in a law enforcement record, and court records would be records created or stored by the juvenile court or sometimes by juvenile probation. Many states don't actually distinguish between what is in a court record versus what is in a law enforcement record, so we don't necessarily know whether the confidentiality of protections apply broadly. And so in order for records to be adequately protected, the information that is protected needs to be comprehensive, and the information needs to also extend, or the confidentiality needs to extend to all types of records, court records as well as law enforcement records. The second core principle really relates to access to juvenile record information, and this is, when it comes to confidentiality of information, this is really where states vary quite a bit. So the reason why records can be stigmatizing to youth and can cause all these collateral consequences is because they're generally, in many cases, they're generally available to the public. So we wanted to ensure that in order for records to be protected adequately, there shouldn't be any disclosures or overall inspection by the public. Now, we acknowledge that record information must sometimes be shared outside the individuals who are directly working in the case, but that there needed to be limitations on that information. And so we want to ensure that access to juvenile record information is limited to the individuals connected to the case, including the court people, the court personnel, the agencies that are responsible for supervising the child, like agencies that are placing the child or overseeing them through probation, the juvenile and their attorney, the parent, the prosecutor, and also that any other type of request for access to juvenile record information would be handled through a court order, so that there would be some sort of process in order to determine whether or not there was a need to share that information. But most states have some sort of exception for law enforcement. For example, law enforcement in Rhode Island, access is only provided to law enforcement when it's deemed necessary for law enforcement officials to fulfill their official duties. So this could include for investigative purposes or determining eligibility for a first-time offender program or a diversion type of program. Many states give carte blanche access to law enforcement. Another few, few agencies that routinely have access to juvenile record information are schools. The vast majority of states provide juvenile record information to schools either prior to adjudication or even after adjudication when the disposition is handed down. Some states safeguard this information. So, for example, in Vermont, the school has to obtain a permission from the court prior to accessing juvenile record information. In Louisiana, the information must be relevant and necessary to the performance of duties and enhancing services to the juvenile and the family. So it's not necessary that it's not necessarily protective to just provide information to the school. We want to ensure that there are some limitations on that and that there is some process and safeguards to ensure that the information isn't being used to cause further damage to the child's ability to succeed in the future. I also talked a little bit about government agencies, victims. Many states provide for victims of crimes to have juvenile record information. And then for research, generally speaking, research entities can obtain juvenile record information as long as the information is de-identified. There are some states that have provisions, state statutes that govern research entities obtaining that information as well. And then the last group of individuals that might seek juvenile record information, where the information really needs to be safeguarded, is by the media. So some states specifically permit the media to have access to juvenile record information. Some states safeguard this by saying that they can only have access to juvenile record information if they certify that they won't divulge confidential information about the child publicly. And states like Delaware and Georgia, they only grant media access if there's a request made by a media outlet and it goes through a hearing and the court orders that information can be accessed. Finally, one core principle that we set forth is that there should be some sort of sanction for sharing of confidential information. This is generally for private agencies or private databases that are posting information, and we wanted to see this as a deterrent for posting confidential information, and so have set forth a core principle that there should be a fine for individuals that intentionally or agencies that intentionally disclose confidential information, but ensuring that those penalties are not that youth who share their own confidential information aren't subject to those same penalties. Now I want to move into sealing and expungement. So states really, according to our core principles, states really are not doing exceptionally well when it comes to sealing and expunging juvenile records. Now earlier we talked a little bit about the difference between sealing and expungement, so I want to just, oops, I'm sorry, let me go back. I just want to explain a little bit about how we set this forth as a core principle. So if records are being sealed, that they should be segregated and both physically as well as electronically if the records are being maintained electronically, so that only the individuals that are statutorily permitted access to them have access to these records. If records are really being expunged, and expunged by definition that they are being destroyed, and the effect of which is that they've never existed, then they should be physically or electronically destroyed and deleted from the files. It shouldn't be that, you know, the clerk of the court has a drawer in their office that says expunged files, and all the files that are expunged are in there. And truth be told, we've heard that is what some people do. So we really want to look at to see what the effect of the expungement is, and the effect should really be that when sealing occurs, the definition of that there is some limited accessibility, that's what's actually happening, and when expungement occurs, that they are actually physically being destroyed. And then as I discussed a little bit when we talked about confidentiality, it's really important to know what information this is applying to. So the core principles are that, you know, both law enforcement as well as court records should be eligible for expungement. Expungement is really only effective when it applies to all types of records. For example, in Wisconsin, expungement only applies to juvenile court records. So while the court might abide by its own order and get rid of the juvenile records when there's an expungement order, the information doesn't go to the state police, and then law enforcement files would still be accessible. And anybody who did like that type of background check would be able to get that information. Hawaii is even worse, actually, because they permit expungement only of arrest records. So court records or any type of record related to an adjudication of delinquency would still be accessible. But most comprehensive expungement really includes law enforcement records, court records, as well as law enforcement records that include fingerprints and DNA information. Several states spell out that law enforcement records or expungement pertain specifically to fingerprint information and DNA information. Idaho, for example, specifically refers to expungement of juvenile fingerprints and DNA, and Michigan similarly provides for sealing of arrest and fingerprint records in certain circumstances. Now, one core principle that we felt was really important, and this is an area that is not found in many state statutes, but we believe it's an integral part of good records policy, is the notification of sealing and expungement rights. So the reason is that if the mechanism exists, if sealing or expungement exists in your state and kids don't know about it, how possibly can the mechanism be effective? So we want to promote notification at several points of the process and by several different players in the process. So I've divided this up into the time of the proceeding as well as the content. And so the individuals that should be providing the child with information about the collateral consequences of their record and information about their expungement rights, it should really be happening at all stages of the proceeding, by the kid's attorney, by the court, by the probation officer, at the time of eligibility, and by the clerk of court, even when the expungement has actually happened. In Nebraska, for example, even DAs are statutorily required to inform kids in written plain language about the record sealing process and what it means. A number of states also that require notification simply say that the court or another agency must advise offenders of their right to expungement at some stage of the proceedings, but really effective notification should be much more comprehensive than that. Kids should be made aware of the consequences of being adjudicated delinquent, you know, certainly when they're entering an admission, but at any point of the proceeding, if they are even going to trial, they should be made aware of the consequences, both immediate and direct, as well as the collateral consequences. Information about their rights to expungement and the difference between a sealed and expunged record, if there is a difference in their state, as well as the timeline for automatic expungement or expungement by petition, if there's some sort of petition that's required. And you know, the benefit of having players throughout the system involved in the child's case provide this information is that they can provide very specific information about the child's individual eligibility for expungement. There are some really great programs out there. For example, Illinois, the clerk of court sends a notification of possible right to expungement postcard to people at their last known address when they turn 17 or 21 for cases when they're eligible. So if a child is eligible at age 17, they get a postcard in the mail that says that they might be eligible for expungement. They should, you know, see they should obtain information from the Office of the Appellate Defender to get more information about how to go about doing that. Texas also has automatic expungement, so they provide for, you know, expungement without the need for a petition or a hearing in many cases, and yet still they have a really great notification requirement where the child is informed about the automatic nature of expungement and how the record might affect them, as well as the entire process for seeking the sealing or expungement. But because there aren't a lot of statutes on this, and this is an area where the law doesn't necessarily speak to notification in many states, there have been a lot of web-based notification tools developed. The MICVA Challenge in Illinois created expunge.io, which is this tool. It's a web-based application where kids can put in their information about what type of offense that they were adjudicated delinquent for, and they go through a process that explains to them, you know, on a personal level, based upon what information they're adding in about their eligibility for expungement, and then directs them to a legal services attorney in order to get their record expungement petition filed. After the MICVA Challenge and did this in Illinois, several states followed suit and created their own. There's Expunge Maryland. The Louisiana Center for Children's Rights also created one, and a group of youth connected to our office, actually, Juveniles for Justice, worked on Expunge Philadelphia with the Philadelphia Public Defender's Office. So this is not necessarily a statutory range, but this is really a statutory change, but it's really an area where policy reform by agencies and advocates can fill the gap. Moving ahead, just I talked a little bit about the automatic nature of expungement, and we really see that as the gold standard, that in order for expungement to really be effective and to ensure the least amount of burden on youth, and so that you don't necessarily have to have extensive notification requirements and information about how to fill out forms and everything, is to have a much more automatic expungement process where at a bare minimum, diverted and dismissed cases are automatically expunged. At discharge from the case, records are automatically sealed, and then at some point after proceedings have ended, you know, in a duration of time, 5 years perhaps, if there have been no subsequent pending adjudications or convictions for those 5 years, or 2 years if it may be, that there would be an automatic expungement. And then also provide for an early expungement opportunity by filing a petition or having a hearing. In many states, eligibility for expungement really depends on a number of factors, whether it be age, offense, or the duration of time. Most states, eligibility is contingent upon age. for ages 18 or 21, but there are some states that make that a lot later. For example, in Minnesota, records of delinquency petitions for expungement can't be filed until the person reaches 28 for several offenses. There are also exclusions in many states for certain types of offenses. 26 states actually exclude felonies from expungement eligibility. Some states say that if there's been more than one offense that they would exclude from expungement eligibility. And then there are also duration of time. So there would be, depending on the amount of time that has passed. So 2 years after they've been discharged from the case, or 5 years after they've been discharged, there might be an eligibility for expungement. And then similar to the confidential information, we wanted to ensure that children who have expunged records, that information isn't being shared inappropriately. And finally, because the fee for sealing or expungement can really be burdensome for kids, we want to ensure that children have the ability to access record expungement and sealing without paying exorbitant fees. For example, in Oregon, in order to set aside a juvenile adjudication, a child must pay a fee of $80 to the state police, as well as a filing fee that's over $250. So just very briefly, I know I'm running very low on time, so I apologize for going over, but very briefly I want to touch on the policy recommendations. So based upon our core principles, we've set forth policy recommendations that you can find in our national review. There are a number of policy recommendations for people at the state legislature, as well as within the juvenile courtroom. So the legislative changes can be made based upon the core principles. Courts can make changes so that youth are more aware of the collateral consequences of their records and of the expungement eligibility, and they can also ensure more confidentiality during their proceedings. Lawyers have a lot of ability to oversee sort of how children are understanding the records process and the confidentiality. And then finally, there are a lot of things that agencies can do, especially in relation to the notification core principle that I talked about. They can create educational materials to talk to kids about their records and conduct trainings to explain to youth and families about their record eligibility, expungement eligibility, as well as the need for confidentiality. And then just very briefly, I want to mention the REDEEM Act, which is a federal piece of legislation that's set to be introduced in the next few days, I believe, by Senators Cory Booker and Rand Paul, that provide for automatic sealing and expungement in certain cases of nonviolent offenses for youth. And that's just one other policy change that is hopefully very imminent. So thank you so much, and I'm going to turn it over to Kirsten for a little bit of a discussion about what's happening in her state.
Okay, thanks so much, Ria. That was great. Do I have control? I don't think I do. Well, thanks so much, first of all, to NJJN for putting this together and for inviting me to speak. And also thanks so much to Ria and JLC. I know here in Delaware, we have found those reports incredibly helpful as we've been strategizing about how to improve expungement procedures here locally. Next slide, please. So a little bit about me. I work for the Delaware Center for Justice. We're a statewide nonprofit based out of Wilmington, Delaware, and we work with a variety of justice-affected populations. We have programming that works with at-risk youth who have come into contact with the system, and also victims, and we also work with adults. So we really became interested in this issue because of our direct experience working with our clients. We see firsthand the detrimental impact that a criminal history has on someone. And there's nothing more difficult than when you have a client who is dedicated to change, but they're tripped up by these structural barriers that prevent them from moving on and succeeding. So about 2 years ago, we got involved with an informal coalition of folks around the state interested in reforming both the adult and the juvenile expungement procedures here. And strategically, we have decided to move forward with pushing the juvenile expungement efforts through first. Next slide, please. So I thought I would piggyback off of Ria's presentation and give you a brief overview of what the expungement landscape looks like here in Delaware. Delaware didn't do so well on JLC's report. I think we got 2 stars. There's a lot of room for improvement here. So one thing I wanted to start out with is that in Delaware, as of 2012, expungement, as we use the term, no longer involves the destruction of records. So this really ties into what Ria was saying, that it's important to understand that areas sometimes have flawed definitions that they're using. So all of our official documents and statutes use expungement, but that really just means that a case is being removed from a criminal history here. Unfortunately, it doesn't mean that the records are actually destroyed. One good thing is that the records are not available to the public here, but there are many exceptions to confidentiality. We also have no automatic expungement. It kind of falls into 2 paths here in Delaware. Either you qualify for mandatory expungement, and the court has to expunge your record, or you qualify for discretionary, where there may be a hearing involved. And which path you're on, like Ria said, it depends on age, offense, and duration since the case is closed. But even if you qualify for the mandatory expungement, you still have to go through a process of going to several offices to get your criminal history record, go back to the court to file. So there's a lot of hoops involved. We have no formal process to notify youth of the expungement process or their eligibility. I think Family Court here has put together some fabulous resources that are available on their website, and I think the defense attorneys in the state and Family Court do their best to educate kids about the process, but there's no automatic trigger system to remind youth. And then I think the biggest thing here is just that the opportunity for expungement is incredibly restricted. We limit a lot in terms of who is able to apply based upon their offense and the amount of time. So it's a very limited window of people who are even eligible to apply. Next slide, please. So as I said, Delaware has a lot of room to improve. One decision that we've made strategically is to try and put together a big reform package and try and do a lot of changes at once rather than picking and choosing things that we could get through in separate bills. A lot of our reasoning for this is because we have found that legislators often get I guess reform fatigue is one way to put it. If we were to pass one piece of juvenile reform and then we try and bring another piece to them next session, a lot of times we'll hear that they feel like they've already addressed the issue and they don't like picking it up year after year. So it's better for us to try and put together a larger package, which can sometimes pose challenges if there are 1 or 2 controversial elements intermixed with things that maybe aren't as contentious. So one thing we're trying to do here is to prevent convictions for minor offenses from barring expungement. There was actually a Supreme Court decision in the state that came down just this fall that said that driving offenses can no longer count as like a subsequent adult conviction to bar somebody from expungement, and that was a big victory for us. And I think what was even bigger is in that decision, the Chief Justice, in the opinion, they made a comment about how confusing the expungement procedures are here and really urged the legislature to simplify the way the process is written and the way it happens. So that kind of opened a door for us to try and push something bigger through. We're also going to be trying to push for the automatic expungement for misdemeanors when it's been terminated in the child's favor. And then, as I mentioned, we're also going to push to expand, to broaden the qualifications for people to be able to apply for expungement. I don't want to get in the details. I'm happy if people want to follow up with more questions about the specifics, but essentially in Delaware, if you have more than 2 misdemeanors, you are ineligible for expungement, or if you have 1 felony and then another misdemeanor, you're also ineligible. So it's a very limited window, and we're hoping to widen that window. And then we are also looking to relieve some of the financial burden associated. As Rhea mentioned, there are lots of different fees involved, and it's particularly challenging when youth are trying to come up with the money. We were successful last year to convince the family court to set the filing fee to 0 for filing of juvenile expungements. Prior, it had been about $70. So that was a great victory, and it's a big relief for children. But that being said, the court has full authority to reimpose a fee at any time if circumstances change. And then also, since youth have to, since there is no automatic expungement, they have to go and get a copy of their criminal record. That carries a $52 fee, and we're still working on figuring out a way if we can get that fee waived for youth in the state. And then probably the most controversial thing we're trying to do is to add a catch-all provision that after a certain amount of time, if an individual doesn't have any subsequent adjudications or adult convictions after a period of however many years, that they can apply for a discretionary expungement. Next slide, please. So quickly, because I want to make sure we get time for questions, some of the strategies we have employed to push these reforms forward and some of the obstacles we've faced. Last year, we introduced a bill, and we worked very closely with the Attorney General at that time to try and come to a compromise on a bill. And there was a lot of energy expended there, and unfortunately, we weren't able to get something through before the end of session. Since then, we have a new Attorney General in the state, and therefore a whole new administration. So we kind of have to start at square one with building that relationship with the office to figure out if there are areas to compromise. I think our strategy has been to be incredibly proactive with the new administration. We have made sure we have as many people as we can contact our new AG and let them know that this is an issue that they care about. And so we are still kind of awaiting his opinion. But I think the biggest challenge has really been addressing some of the educational gaps around expungement and addressing some of those myths. As Rhea said, I think there's a general perception that once you turn a certain age, your juvenile record kind of disappears, and it couldn't be any further from the truth here in Delaware. So working to re-educate that, first pointing out that a problem really exists, and then also educating on why we need to change the limitations that exist currently. And like I said, our Chief Justice here even commented on how complicated our juvenile expungement procedures are. So that has posed a real challenge when we try to simplify the message for kids, for lay people, for legislators. There's it's a maze, depending on what you were charged with and how much time has passed. So our original strategy had really been to try and simplify the issue to the extent of just focusing on the collateral consequences. And that worked to a certain degree until we started hearing more opposition to some of the reforms. A lot of what we were hearing were very specific challenges about concerns about officer safety and concerns about really violent youth being able to manipulate the system and hide their criminal records. So when we started hearing those arguments, we realized that we needed to develop a messaging that very specifically explained who was impacted by the changes we were proposing. You know, what does the current expungement procedure look like, and what are the changes to alleviate some of those fears that were bubbling up that weren't being addressed by kind of the simplified messaging we were using. I think one of the most helpful ways that we built more support for the issue is just building really strong community partnerships. We have a group we're probably up to about 30 or so youth serving agencies from across the state who support this issue. You know, Wilmington is experiencing a really high level of violence right now, and I think the community is really seeking answers, and it makes the legislature and various state leaders very hesitant to push anything that could potentially be viewed as soft on crime. But when we empower the community to really speak up about how these statutes and procedures affect their sons, their brothers, their neighbors, and that this is something that they believe in, and actually we found that to be helpful in addressing some of the fears. I know I went through this pretty quickly because I want to give time for questions, but next slide. Here's my email address. I'm more than happy to answer any more specific questions about the messaging that we have found to work and what we found didn't work. And thanks so much for inviting me to talk a little bit about Delaware's experience.
Thank you, Kirsten, and thank you to Rhea. We really appreciate the presentations. If folks can stay on a little, we'll try to get to some of the questions, but we can also send them any questions that you wrote, and they've agreed to get back with the person and with a response. So if you have additional questions, I would suggest writing them in as opposed to doing the hand raise on the webinar software. So I'll just get to see how many we can get to here. One question was, do any states enforce penalties on victims who disclose confidential information?
So the provisions about sharing confidential information, that can apply. We didn't find specific states that exempted victims from that, so my assumption would be that that statute could be applied to victims as well.
Okay, great. Then another person wanted to know, said, great research and great presentation, Rhea. What time frame would you recommend for expungement? How many years after which it should be available, or by what age?
Sure. So within our core principles, we've sort of set forth a tiered process where records are automatically sealed as soon as the case is closed, that if you have confidentiality throughout the course of proceedings. So generally, the public should never be able to access juvenile record information, whether it's during the course of proceedings or directly after the course of after the case is ended. And then we would recommend automatic sealing at the point of the case's discharge, and then expungement, an automatic expungement within 5 years, as long as the case is the child has been crime-free in that 5-year time. The ABA actually, for certain offenses, actually recommends 2 years in their IJA ABA standards from the early 80s. And then, that there should be an expungement by petition at any time. So at any point in time, if the child thinks that their record is, prohibiting them from something, that they should be able to apply and make the case and have a hearing, and the burden should really be on the state to demonstrate that there is a need to retain the record at that point.
Okay, great, thank you. Another question is, if there has been an expungement, how does this impact the victim or survivor?
Well, in terms of the the child has been through the court system and has gone through the disposition and the amount of time for supervision and treatment that was dictated by the court. So we don't see this as something that is having a negative or positive impact, really no impact on the victim, because the record of the offense of the child's adjudication, that's not necessarily dismissing the accountability for the offense in any way, shape, or form.
Okay. The next question is, this person wants to know whether there's an advantage to the court keeping some records. Example, to address removal from Megan's Law after 15 years. As these records could include positive treatment progress reports that the juvenile or family may not keep or could be obtained at a cost.
That's a really great question, and you know, what we have seen is most of the states that have some sort of registration for juveniles under Megan's Law or under the Sex Offender Registration and Notification Act, those offenses are exempt from any type of expungement eligibility. So that type of record information is kept. In a number of actually, I believe that the federal legislation for SORNA requires that the child be engaged in some sort of sex offender treatment program and be fulfilling their obligations to either continue to go to the treatment program or be successfully discharged from the program. That information would then be kept in their SORNA file or whatever it might be, and so I don't think necessarily that the juvenile record information would have as much bearing on those decisions.
Okay, great. We have another question here wanting to know, is there, whoops, I think it just went down, sorry. Is there any case law or main lawsuits in the country against those that have violated sharing of information laws?
Great question, and I don't know the answer to that, unfortunately.
Okay. We have another question. Is there usually a cost for filing for expungement?
Yeah, and in many states, and it can be, as Kirsten talked about, like there are varying ways in which these costs are assessed. It could be the filing fee for the petition if a petition is required. In some states, there's actually a fee for actually expunging the record, so you have to file a court filing fee, and then you also have to file like a processing fee for the actual expungement of the record. I mean, I talked about Oregon, which has a really high fee. There are only 15 states that we saw that specifically provide for in their statute that there is no fee for expungement, but fees can be assessed by the municipality or the court or any of the agencies. We've also seen, you know, a lot of private databases have juvenile records, like information is shared with private databases in order to store the information, and even if they have the information incorrectly, like you don't know that the expungement order should be sent to this private company that posts the information online. If you send them the information, they'll say, sure, we'll take it down for you, we'll abide by this court order, pay the $60 fee in order to take this information down. So there are fees across the board.
Okay, and I think we're going to take one last question that we have here, and that is, this person wanted to know what the rationale was for requiring a young person to have to ask to have their records expunged. Why anybody thinks that's a good idea?
I don't know historically what the rationale is. That's typically the way that expungement statutes came about. As long as expungement has been around, it's been sort of by petition. And so states have been taking proactive measures to make things more automatic, especially in some cases like in Delaware, as Kirsten mentioned, with the misdemeanor offenses. But I think that the idea is that it's on the kid, and this is, you know, this is my speculation, is that it's on the kid to prove that there is no longer an interest in keeping this record, when I think that the burden really should be shifted, that the the state should have to demonstrate that the record retention outweighs the child's interest in having their, past record destroyed or removed.
Great. Okay, well, I think we're running out of time, so if we didn't get to your question, we will send your questions to the presenters to answer. And I just want, again, to thank Rhea and Kirsten. We really appreciate your presentations and appreciate everybody phoning in. And we hope you'll rejoin us again for future webinars. Thank you so much.